You are now live.
Good afternoon, everyone. Thank you all for joining us for today's webinar. It's brought to you by the Immigration Section at MSBA. My name is Deborah Ninen. I will be introducing our speaker for today. We're going to be discussing cancellation of removal for non-lawful permanent residents. This is a critical defense that is available to individuals who are not certain non-citizens who are in removal proceedings, and if they have certain family members here in the United States. We will cover the eligibility and procedural requirements for applying for cancellation of removal for non-lawful permanent residents, but we'll also be discussing best practices for developing your record and presenting evidence before the immigration court. Our speaker for today is Kate Stenlick. Kate is a graduate of the University of Baltimore School of Law, and she has practiced immigration law for many years. She worked as an associate attorney at a law firm in Annapolis, Maryland, before starting her own practice in January of 2018. She's both a member of the Maryland State Bar Association as well as American Immigration Lawyers Association. Before we begin, I just want to remind you that if you have any questions, I encourage you to ask them in the comments below, or you can email Bill directly, and his email should be on your screen. It's bill@msba.org, so that we can be sure to address any questions that you have during the webinar. So with that, I'm going to hand it off to Kate.
Hello. All right, I guess we're going. So I'm Kate, and we're going to be talking about cancellation and removal for non-lawful permanent residents. We can go to the next slide. Just before I get started, I just want to make a clarification that there are two distinct forms of relief. One is cancellation or removal for non-lawful permanent residents, but there's also one for lawful permanent residents. So the first thing you want to make sure you're in the right category is what your client's legal status is. If they are a lawful permanent resident, you're going to want to look at the distinct relief, which is for cancellation removal for lawful permanent residents. Today, we're only going to be talking about cancellation of removal for non-LPRs. The code that you want to look at is INA 240AB1. I'm just going to go over the basic requirements right now. First is that it is a defensive application in removal proceedings. This means there's no way to affirmatively apply for this. You can't just submit an application to USCIS. Your client has to be in deportation proceedings in order to apply for this. Some practitioners might want to even put a client in removal proceedings in order to apply for this. I would recommend against it, but it is something depending on the circumstances. You know, technically that's something you could do, but in general, putting a client in removal proceedings is never a good idea. So this would be something, if the client is not in removal proceedings, you can discuss it with them in case they are picked up by immigration. But if they're not already in proceedings, you cannot and should not apply for it. The application is the EOIR 42B, and you have to pay a filing fee. There are instructions available online for how to pay the filing fee. It's similar to if you've ever feed in an application of just a plain 485 or submitted the defensive asylum application, but you just can look up those instructions online to pay the filing fee. Technically, best practice would be to file the the EOIR 42B with the filing fee, the receipt of the filing fee with the court. Some judges will let you file the EOIR 42B without the filing fee, but they can reject it without it. So you will need to file the form with the filing fee with the court. So to be eligible to file the EOIR 42B, the applicant must be physically present in the United States for 10 years, have good moral character for 10 years, not be convicted of certain offenses, and show that deportation would cause exceptional and extremely unusual hardship to a qualifying relative. If the application is granted, they receive a green card. Unfortunately, however, the green cards are subject to a cap. I believe it's 10,000 per year that they issue, and unfortunately, there's a huge backlog. It's been a little while since I've had a client granted. I think I had one last year. It took about 2 years, I think, from date of the hearing to actually get the approval. During that time, obviously, they're not going to be deported. However, if they do pick up a new criminal charge or something drastically changes in their case, it could adversely impact their eligibility and they could lose that benefit. So it's important to keep in touch with your client from the date of the hearing until you actually get the approval, the decision from the judge granting them the relief. We can go on to the next slide. So first we're going to talk about continuous physical presence. So again, they have to show that they have been in the United States for 10 years. The question is, when is that relevant 10-year period? And we talk about there are certain things that will stop the clock in terms of accruing that physical presence. The first key one is the service of a notice to appear. Now, this has been an area of law that's been changing recently. The Supreme Court in Pereira said that in order for the clock to stop, the notice to appear must include all relevant information, including the time and date of the hearing, in order for the clock to stop for physical presence. If you've been practicing immigration law and looked at any of these notices to appear, you'll notice that about 99% of the cases, they don't have a time and date of hearing. They say TBD, TBD. So after Pereira, it seemed like, and essentially, if unless DHS served a new NTA on the client with a notice and with the time and date of hearing, the clock simply doesn't stop. So this was, kind of crazy for many cases, since most clients are in removal proceedings for many years, and they're continuing to accrue physical presence while in proceedings. Unfortunately, not long after, the BIA in Bermudez Coda said that the clock will stop after the client receives notice of the hearing, as in the notice that the immigration court sends to your client. So unfortunately, for most cases, the clock would stop shortly after service of a notice to appear. But it's important to look at each case individually, because sometimes the client is served with the notice to appear, but might not actually get their initial notice of hearing for 1 or 2 years. So you'll have to look at when the client actually got notice of hearing, whether it's on a notice to appear that actually has time and date of hearing, or receiving the notice of hearing to determine what date the clock stopped. And then you work backwards from that 10 years, and that's the relevant 10 years you will have to prove that the client has been in the United States. And just a note that there is, and I meant to pull up the citation, but I couldn't find it. There is a Fourth Circuit case currently pending regarding whether this two-step analysis that the clock will stop after notice of hearing is proper. So if you have a case currently pending where there's an issue of, maybe the client had 9 years before they got the notice of hearing, you might be able to ask for a continuance while this Fourth Circuit case is pending, since it could impact your case, whether the client is eligible for cancellation of removal. I know I have a case, for instance, that I got a motion to reopen granted based on Pereira because the client is now eligible for cancellation of removal, but now he's not, and his individual hearing is coming up. So I'll be asking for a continuance, hopefully, until this Fourth Circuit case will be granted, or a decision. I'm hoping it'll be granted. So that should apply for every case, because every case will have a notice to appear. Now, other cases, the other reason why a clock would stop is commission of certain offenses. So if your client has a criminal conviction, you'll have to look to see if that also will stop the clock. The relevant crimes are noted if you're inadmissible under INA 212A2 or deportable under 237A2 or INA A4. Now, we'll talk specifically about criminal convictions when it comes to good moral character and the other part of the presentation. Most criminal convictions that are serious enough to stop the clock also make the person ineligible for good moral character. So in reality, it's kind of moot whether the clock stops, because if you're ineligible for a criminal conviction, it doesn't matter if you have 10 years, but it's something to keep in mind. Next slide. The clock will also stop because you have to show continuous physical presence. So the clock will stop if the applicant is outside of the United States for a certain period of time. In general, it's one absence of more than 90 days or an aggregate of all trips more than 180 days. It's basic, it's math. You have to figure out what day your client left, what day your client returned, and then do the math. And if they've done more than one trip, then you got to add the days up. The clock will also stop after departure under threat of deportation. You have to specifically look at the facts of each case and determine whether the person left because they were in danger of deportation, such as if they were ordered deported by a judge, an expedited removal at the border. A voluntary departure typically will stop the clock because they're usually taking voluntary departure in lieu of an order of deportation. But there is some case law to suggest that if there's no evidence that they were actually advised that they had a right to see a judge or that they were taking it in lieu of an order of deportation, it might not stop the clock. So, just you'd have to look at the case, look at the actual circumstances. Next slide. So in order to prove the physical presence, as I already touched on, first you have to figure out what the relevant 10 years is. The client was served with a notice to appear and the notice of hearing in 2014. You'd be proving the client was present from 2004 until 2014. And depending on the circumstances, you really have to get down and dirty with the dates. With if they were served with the notice of hearing on March 10th, you got to prove that they entered before March 10th, 2004. Also look at if there's any absences. One of the key ways that DHS will know if there's an absent is if there are stops at the border, and you have to look at whether it was under threat of deportation. And then if your client really was outside the United States for only 90 days, you will have to prove those 90 days, and show that the client was actually there on day 88 as opposed to day 90. And it's evidence-based. You really have to get your paperwork to show your work. One of the best ways to show that someone's been in the United States is pay stubs. Clients not getting paid if they're not doing the work in the United States. So try to get pay stubs for as far back as possible. Phone records also will work. I see a question. We'll get to that after. Phone records also will be good at showing physical presence, especially if they're showing where the call is coming from. Bank statements also are good. Taxes can be a little tricky because depending on how much the client has claimed that they've worked, if they're only claiming $8,000 or $6,000 in income, arguably is that part-time, they only worked for a few months. So taxes are not the best for proving physical presence, but they at least show that the person most likely was in the United States for at least a period of time. After those, any kind of bills, mail, I tell my clients, show me anything that you have that has your name and a date on it. Receipts, cards, invitations to birthday parties, anything that they have. Unfortunately, that this often means banker's boxes full of just envelopes that you have to kind of go through. I usually will go through, highlight the client's name, the date, and then organize them by date to submit them. If you don't have these types of paperwork, affidavits with supporting documents can also work. Have a coworker write an affidavit saying, I know this person, we work together, I never remember them being out of work for more than a week or so, something like that. And then if you can also get supporting documents to show that they work together. Make sure if they say we work together for this company, make sure you have proof that the client worked for that company in order to make that affidavit more credible. I believe the question was about administrative closure and if that should stop the clock. I don't believe that if the case is administratively closed, that should not stop the clock. The case is pending, but that's only if the notice to appear has not stopped the clock already. So only if Bermuda's coda is overturned to say that a notice of hearing does not stop the clock, then administrative closure should not stop the clock. Leases, yes, leases. So the other question is, are leases for apartments useful? Absolutely. That also will help corroborate because part of the application for the EOIR 42B is to list every address the client has lived at. Technically someone could just make up addresses and say, I lived here for 3 years to show that that's where they've been. But leases will then corroborate those statements on the application. And obviously having, 10 years of addresses is kind of the basic level of proof you will have that you have been living here for 10 years. I missed that question.
We have another question. Is should the EOIR 42B be filed at the master calendar hearing or?
Yes, so I honestly filed the EOIR 42B and pay the filing fee as soon as possible. You don't have to file it at the master calendar hearing, but the judge might give you a call update to file it either 60 days before the hearing, 60 days after the master. But I file it as soon as possible because the payment of the filing fee, the proof that the application is pending, is what will give your client a work permit. And if you've done immigration law, permiso, work permit, that is the almost more important than the green card. They just want the authorization to work. They want the social security number. So once you have the proof that you paid the filing fee and the application is pending, your client can apply for a work permit. So file it as soon as possible. Otherwise, yes, do it at the master calendar hearing. But again, it's really not necessary usually. You can just plead that the client wants to pursue cancellation or removal, and then the judge will tell you when you need to file the application. I think there was another question.
A follow-up question is, once the merit hearing is completed, does the immigration judge decide on cancellation of removal at the hearing?
Good question. So usually all the cases that I've had for the most part, well, actually, no, that's not true at all. The judge used to not be able to tell you if they were going to approve or deny it because there was no visa available. I have had judges tell me, okay, your case is approved, but I don't have a visa available. I believe the IJs now have the authority to deny an application without waiting for a visa, but that hasn't happened to me. So I think judges kind of do what they want. So basically, there's a possibility you'll get the decision. There's also the possibility, I know my most recent one, we don't know if they're going to approve it or deny it. I'm hoping he's going to approve it, but we have to wait for the decision. If there's no other questions, we can go on to the next slide. Okay, so as I said before, criminal convictions will affect a client's eligibility for cancellation of removal. This is the basic list. I'm not going to go through each of one of them because if you've done anything with immigration and criminal convictions, you know that this is it's a moving body of law. There's constantly case law that changes what counts as a criminal conviction under one of these categories. The biggest one is a crime involving moral turpitude. There is an exception, which is why there are stars there. But basically, if you have a criminal conviction, no matter what it's for, make sure you check the statute, check this list, check case law to see whether or not it will be an absolute bar. We'll also talk about good moral character because no matter what the criminal conviction is relevant. But the question is whether or not it will be an absolute bar. And sometimes good luck. It's a lot of work trying to figure out whether it's an absolute bar or not. You can end up having a whole hearing before eligibility for cancellation or removal just on whether or not the client is eligible. I tend to try to stay away from criminal cases for this reason. But anyway, we can go on to the next slide. If you find that the client did commit a crime involving moral turpitude, there is one small exception, and that's if the client only has one CIMT conviction. The sentence was 6 months or less, and that's sentence, not time served, and the maximum penalty was less than 1 year. Now, the wording of that is less than 1 year. So if the maximum penalty is 1 year, it does not qualify under this exception. It's a slight different than the petty offense exception for other areas of law. But if you have a client who has one CIMT, but it's a misdemeanor and the maximum penalty was only 6 months or 8 months or 9 months. I think it's usually 6 months or a year, but if the maximum penalty is less than a year and the client was only sentenced to less than 6 months, they are still technically eligible for cancellation of removal. We can go on to the next slide. All right. So even though if the client is still eligible despite criminal convictions, you still have to prove good moral character. There's statutory bars for good moral character. You can find them at INA 101F. Some of these exceptions, the client doesn't even have to be convicted of a crime. If they admitted to committing certain acts, it can be a bar to good moral character. So it's broader than the criminal bars. Now, if you remember from before, I said it's good moral character for 10 years. However, there are a couple permanent bars. So even if they were committed outside of the 10 years, they still will be a bar for good moral character. And that's a conviction for murder or an aggravated felony, which again is a term of art. You'd have to do the research to see if the conviction qualifies as an aggravated felony, or if the person engaged in persecution, genocide, torture, or other severe violations of religious freedoms. We can go on to the next slide. So the rest of these bars would be only if they are committed within the 10 years. Now, it's a different 10 years than if it's than the physical presence 10 years. 10 years of good moral character is calculated from the date of the decision back. So it's a little bit easier than the 10 years of physical presence. Some basic bars are if you were, and then again, this is where I say it's a conviction or admission of a drug offense. Now, admission is also it's a term of art. You'd have to do your research about what could potentially qualify as an admission. And it's still pretty difficult. If there is no conviction, it's difficult for DHS to prove that there was an admission to actually bar a client from eligibility, but it's still something to keep in mind. There is an exception for the drug offenses, is if the possession is less than 30 grams of marijuana. How you prove it was 30 grams of marijuana is another thing you have to keep in mind, but it's a good exception. There's also conviction or admission of CIMT, total sentence of 5 years or more for 2 or more convictions. So if your client has multiple convictions, you have to look at do the math of how long the total sentences are. Engaging in prostitution, if there's reason to believe the client is a drug trafficker. So if the client has multiple convictions for drug offenses, that sort of thing, you have to look to see if there's reason to believe of a drug trafficker. Alien smuggling, which is also a conviction or an admission. So that one is one you have to look at if there were any interviews done at the border, whether they admitted to smuggling anybody in with them. A habitual drunkard. There was a semi-recent case saying that if the client has 2 or more convictions for DUI in the relevant period, it's an absolute bar to good moral character, because that proves that person is a habitual drunkard. Even if it's outside of the period of the 10 years, you should be mindful if the client has multiple convictions for a DUI, whether there's an argument that the person is a habitual drunkard. If there's convictions, or if there's proof that the person is living off of illegal gambling, basically if their main source of income is illegal gambling, any false testimony for an immigration benefit, polygamy, and serving more than 180 days of jail. So that's different than if the person has actually served time in jail for 180 days or more, that will be a bar for good moral character. I saw there was a question and I missed it.
Here, the question is, can you repeat the difference for 10 years for good moral character and 10 years for physical presence?
Okay, sure. So the 10 years of physical presence, you have to look at what stops the clock. So most of the time, the clock will have stopped before you actually go to your merits hearing, at least under the law right now. However, the good moral character 10 years, nothing really stops the clock. So if the client, for instance, is served with a notice of hearing in 2014 and that stopped the clock for physical presence, and you're proving physical presence from 2004 until 2014, but then your individual hearing is actually in 2020, you have to show good moral character from 2010 until 2020. That answers. We can go on to the next slide. Okay, so then there's the statutory bars to good moral character, but then there's also the discretionary factor of good moral character. In other words, even if your client is not statutorily barred, the judge can still deny your application on discretion if they have criminal convictions or other bad conduct. So the way I usually handle, regardless of what the conviction is for, I have the client be prepared to admit to the conduct. So especially in most of these cases, you will be submitting an affidavit and the client may have to be prepared to testify, especially if there's any criminal convictions. Usually DHS and the judge, no matter what, will want the client to testify as to the criminal history. And so you must prepare your client to be upfront about it. They have to admit to what they did and explain what happened. They have to be candid about it. They can't be cagey. They can't try to pretend it didn't happen. They have to be able to come up with a way to honestly explain what happened, express remorse. I tell my clients, you just, no matter what, you just got to say, I'm sorry for what I did. I learned from what I did. If they don't, they might be denied. And I've just had clients just say, I'm real sorry for what happened. And sometimes that's enough. You should also offer any evidence of rehabilitation. This is especially true if there are convictions for DUI or other alcohol related offenses, because there is that, not only is there the habitual drunkard bar, but you want to show that the client took the conviction seriously. And that's a real easy way to show rehabilitation. Proof of going to AA, proof of going to any outpatient services. A lot of times if they were convicted for a DUI or even charged with a DUI, they're going to be required to go through alcohol classes, that sort of thing, get those records, submit them to the court. And then if the client, regardless of what the criminal conduct was, if the client is able to explain how they make sure that those kind of convictions don't happen again, they should explain it. So it's very important that you prep your client and how to testify and how to frame the criminal convictions, because it will come up. As for discretion, so it's a balancing test. So even if it's not convictions, if there's any sort of bad conduct, such as not being involved in a child's life, not paying child support, those sorts of things, you are going to have to show proof that to counterbalance whatever negative is in your client's file. So evidence the clients is productive, likable, dependable, that sort of thing. We can go on to the next slide. I think there was a question about whether if there was a drug related offense, if it's null pros, if you should bring it up. I would say yes. It's something, or at least be prepared for it to come out. Because like I said, even if it's not a conviction, because of this good moral character discretion ground, DHS can bring it up and use it as an argument for why the judge should deny the case on the grounds of discretion. And so, especially if it was something where, it was a misunderstanding, something really easily explained, just have your client come out and explain what happened. It's still an arrest and a case that's on the client's record. It could come out if you can explain it away and get it out, get rid of it. And plus, the more honest the client is with the court, the more upfront they are about those sorts of things, the better your client is going to look. And hopefully if they can explain it well, it'll be a reason for the judge to grant based on discretion as opposed to denying on discretion. We can go on. Yeah. Okay. So evidence of good moral character. First, if there is criminal convictions, there are criminal convictions, you do want to do what's called a criminal chart. I believe you can find a sample for that in the EOIR handbook. for any arrest, any conviction, any whatever, they will ask, provide a chart that explains when the arrest was, what the arrest was for, what happened, and then whether or not it has immigration consequences. Hopefully all of your convictions, it'll be no, there are no immigration consequences. And then you'll want to provide records of conviction and any records to show, especially if there was a null pros or there was, say, it was steaded, anything like that, you'll want to provide proof of that. And then evidence of rehabilitation, which we already discussed. So if the client had alcohol classes, so evidence of rehabilitation, alcohol classes, anything like that to show that the client has changed. Proof of completion of all probation requirements, especially, if it's a driving without a license and the client needed to get a driver's license, something like that, and the client met all those requirements, that again, it'll kind of counterbalance the fact that the client was arrested to show that the client complied with all the terms of probation. And then, so that's kind of addressing the actual bad conduct. And then you want to show good conduct, highlight good conduct, such as involvement in church, volunteering, donations, any sort of assistance in charity, letters from friends, family, neighbors, payment of taxes will be proof that the client has good moral character. And this is where you can really get creative. There's no cut and dry proof of good moral character. You really have to look at the client's life, the client's case, and see just what you can do to really show that the person is a good person and the kind of person when we think of the ideal immigrant, that is your client. I did see that there were a couple of questions.
Yeah, so we have a question. Even if the crime isn't listed on the I-213, we are supposed to list all criminal charges / convictions on the EOIR 42B besides traffic infractions, correct?
Yes. And then was there another?
Yes, there was a follow-up question to the previous question about whether if a drug possession charge that was null prost, whether it should be disclosed. And she asked, would the client explaining it count as an admission?
So ideally your client would, especially if the case is null prost, you would not, number one, be admitting to that you actually did it. You would and it's tricky. Now, I didn't look into or research again what the admission was, but I know that there's very strict requirements for what counts as an admission for it to be a bar. I know it has to be under oath and in certain circumstances. I don't, that is a good question, and one, unfortunately, I don't know if I can definitively answer that. It's something you'd have to look into, whether admitting it in court. You might have to be creative in terms of how the client testifies, but obviously if DHS is going to ask really hard, they might have to admit to it. So unfortunately, I don't know the answer to that question. Deborah, do you know?
No, honestly, I haven't had that situation come up. Usually if something has been null prost and we're just explaining in the affidavit, the client's affidavit, that something, that this happened, but they were able to get around it, or it wasn't exactly a criminal conviction, or even the facts weren't exactly what the charge was for. Somehow that's been able to get, or I've never had a situation where, them explaining it in their affidavit would count as admission, and then the judge or DHS would use that against them.
Right, that's more or less. But yeah, it's definitely something to keep in mind. You don't want your client to be admitting to conduct, but that you also obviously can't have your client lie, because that would also be a bar to good moral character. So yeah, dealing with criminal convictions is definitely a very delicate area, and especially and as I said, if you have these criminal convictions or even just arrests, anything on the record, you really got to counterbalance it with evidence of good moral character. And like I said, you get creative. This is just a basic list, but just because your client doesn't go to church, doesn't donate, doesn't mean they're not a person of good moral character. You can move on to the next slide. So as I said, you can submit letters. I just kind of threw this together, so please don't judge it too harshly. But this is just kind of a sample of a letter of support. And I wanted to touch on how these letters of support, you can really hit on multiple eligibility categories in one letter. So you want to have if the client has a family member or a neighbor who really knows the client really well, you can have them write a letter. Make sure that they say how long they've known the client. Not only could that be proof of physical presence, but if someone is a real jerk, they're not going to keep people around for very long. So if you have a few letters from people saying, oh, I've known this client for 5 years, 6 years, 7 years, that in and of itself is kind of proof that there's someone worth keeping around. You want to have the person explain how they know the person, especially if they've worked together or lived together or were neighbors, because then that corroborates your client's statements of where they've worked and where they've lived to show that they have lived here as well. And then you want the person to establish how often they see the person. If they only see them once a year, it's not really great. If they see them regularly, really great. And then there's all these buzzwords that are great to use in letters of support. Hardworking, family man, dependable, reliable. You can get, there's all sorts of words, but you want to really throw in a few of those. And then I really don't give your clients sample letters of support, because if you do, chances are you're going to get 15 letters that pretty much say the same thing, and that is not good. You want to tell the people writing the letters of support that the more detailed, the more specific to your client and their lives, the better. So for instance, mentioning, we really like going to their house for barbecues or birthday parties, or we go to the park. That really adds the human side. Good moral character is discretion. So the more you can really paint the picture that your client is a good person and that, they're just kind of a normal person who should be allowed to remain in the United States, the better. You also,
just to add
yeah.
I'm just going to add to that. I always include a letter from the individual's employer as well. I always find that they are always a good judge of character. You can talk about how responsible they are, how hardworking they are, how they show up on time. They're always reliable. Getting a letter from them and usually the employer is always willing to help out your client as well.
Exactly. We haven't talked about hardship yet, but we will. Letters of support can also be used to work on hardship. So basically have them mention the family, whoever the qualifying relatives are, and what their relationship is like. If the client has a criminal conviction like a DUI, and the person knows about this, and knows that the client is remorseful, or if it was, for instance, a DUI, and they know that now they never drink anymore, have that letter reference it. So a good letter of support will hit on each eligibility requirement. But if you can only get one, for instance, a letter from the employer saying that he shows up for work every day, that's also great as well. As I said, do not have the client submit 15 letters that all say the exact same thing. It will not mean anything. It's better to have a few letters from people who know the client really well and have known the client for a long time with a lot of details than to have 15 letters that all say the same thing. But with that being said, having 10 letters from 10 different coworkers all saying he's the guy who shows up for work when I need him, he's the guy who makes me laugh, he talks about his kids all the time, that's also helpful as well. The more letters from different people and different areas of life to really paint a picture of the client's life, the better. I know there were a few questions. Yeah.
We have a question that is relevant to that. Should we only submit letters of support from people with lawful immigration status?
So this is the question I get a lot. It's always better if the client has lawful status. If the person does not have lawful status, technically DHS or their judge could give it limited weight because, they might have motivation. They might have motivation to lie, or they're not reliable, or they're, I've never actually had that be raised, but I technically could. I tell clients, there's different levels of how good the letter of support is. If it's a U.S. citizen and the person's known you for 12 years, that's ideal. If it's an undocumented person who has known you for 12 years, it doesn't mean it's not worth anything. It's better to have something than have nothing. The risk, I mean, I guess that's usually more the hurdle to cross, is that the person who's undocumented is afraid to give their information to the court. Now, I've never seen it where an undocumented person has written a letter of support in a removal proceeding and then gone out and been arrested. Does that mean it's never happened? I don't know. So that I feel like is more the hurdle, is getting the undocumented person to actually submit the letter. But there's no requirement that someone has to prove that they with the letter of support what their immigration status is. Usually I will provide a copy of an ID, a driver's license. Now, obviously a driver's license that says not for federal purposes could mean the person is here without status, but you don't have to submit proof that the person is a citizen. The person doesn't have to identify themselves as a citizen or a non-citizen. So, long story short, I don't think there's anything wrong with submitting affidavits or letters of support from undocumented persons.
And also, to add to that, I also think it's important who the undocumented person is. So let's say if it's your client who is in removal proceedings, but he or she has a spouse or a partner who is undocumented, but they know the relationship between the child who may be the qualifying relative, and they're able to attest to that and provide evidence and support or corroborate the client's affidavit, then I think it's really important to get it from them, regardless if they have immigration status or not. I mean, it is something that you want to know.
Yes, exactly. Okay, if there are no other questions, we can move on. Okay, so hardship. If you've managed to make it this far, proving physical presence, good moral character, this really usually is where the case turns. It's hardship. First, you have to have a qualifying relative. Now, the qualifying relatives are either children who are under 21 and unmarried. Adopted and stepchildren usually qualify. If you have a case where your qualifying relative is a child who is, say, 19 years old, 20 years old, you want to make note of that for the individual hearing, because if your child has aged out at the time of your hearing, then the client is no longer eligible. So you might have to ask for an expedited hearing if the client is in danger, if the qualifying relative is in danger of aging out. Also advise your clients that their children cannot get married until they get their green cards, because if they're married, then they're no longer qualified. Spouse, pretty straightforward, but you have to make sure the person is actually legally married. In some cultures, actually getting that paper isn't something that they feel like they need to do. They have long-term partners, they never get legally married. Make sure you see that marriage certificate in order to ensure that that person actually qualifies as a spouse. Parents also count. Again, obviously biological do, adopted and step parent usually will count, but you'll have to make sure that they do qualify. You have to prove the relationship with birth certificates or marriage certificates. That should be like the initial thing that you submit with your application, if possible, is the proof of the qualifying relatives. We can go on to the next slide. Non-qualifying relatives. So adult children. So first you need to show that the person does have a qualifying relative. And then, but then there's also these things called non-qualifying relatives, such as adult children, undocumented children. They can still count for hardship. However, you have to show how their hardship impacts the qualifying relative, not the applicant. So for instance, if the applicant himself has health issues, technically it's not relevant for hardship, but how does that impact the wife who is a United States citizen? Or if there are, two documented children and then two undocumented children, the undocumented children technically don't count, but how does that impact the documented children, the US citizen children? So you would want to frame that, if the client has to return to Mexico, for instance, and he has serious health issues, how would that impact the USC wife or the children in terms of finances, in terms of mental well-being, in terms of inability to access healthcare, finances? For undocumented children, documented children, how would separation between the children impact them? That sort of thing. It's really a case-by-case basis, but you just have to remember that it doesn't automatically qualify unless you can show how it impacts the qualifying relative. We can go on to the next slide. The standard for exceptional, extremely unusual hardship is that it must be substantially beyond the ordinary hardship that would be expected upon family separation. Obviously, any family being separated, a client facing deportation, is hardship on any family, but you have to show it's beyond the ordinary hardship. There are certain factors that have been held in case law to be considered, such as age of the qualifying relative, health, special needs in school, length of residence in the United States, family and community ties, both in the United States and in the home country, circumstances in the home country, such as standard of living, way of life, languages spoken, work opportunities, and if the client has any other ways of immigrating to the United States, such as through I-130 petition, that sort of thing. These are the basic factors that any case will look at, but they have broad discretion to look at any factor that may be relevant, and it is a totality of the circumstances. If, for instance, the qualifying relative is a spouse, there's no children, and that person is healthy, that doesn't mean that there is no hardship. The judge can't look at this one factor and say, okay, there's no hardship because they don't meet every factor. You really have to look at the totality of the circumstances. We can go to the next slide. On the EOIR 42B, there is the question of whether or not the family will stay in the United States or relocate. This is an important key factor to discuss with the client at the beginning of the case, because you'll want to indicate that on the application, and if for sure the family would relocate or not relocate, that'll determine how you're going to present the case from there on out. It's important to stay consistent with that choice if there is a clear choice. I have heard cases where the judge has kind of dinged the client for credibility if they've changed their answer. So just be prepared. If you put on the application that they will relocate, they have to stick with that throughout the entirety of the case, or be prepared if circumstances change in the case to make them change their mind. I usually err on the side of trying to prove both, just because that way it covers all your bases. So you want to prove not only that if the family was separated, as in the qualifying relative remained in the United States while the client had to live in their home country and unable to come back to the United States would be hardship, but also that if the family relocated together to the home country, that would also not be possible. You can go on to the next slide. So evidence. Just like with the good moral character, you kind of have to get creative. It depends on every family's hardship will be different, and you have to really paint the picture for the judge to show where the hardship is. The basic stuff that you normally will provide is, number one, an affidavit from the client and qualifying relatives to explain I usually go through, explain day-to-day life, what's going on with their finances or like schools, like just their whole life. And then you can explain why, if, for instance, the client had to return to their home country, their lives would change. And if they had to go to the home country, how the lives would change and why it's just not possible. You'll want to provide country condition evidence to show, especially depending on where the client is from, if it's a client with a country with a lot of crime or poverty, lack of job opportunity, lack of schooling, you'll want to provide proof of that to show why the family would not be able to relocate there. And again, depending on the specific circumstances, if, for instance, someone has medical issues, you'll want, and they wouldn't be able to get medical care in the home country, show that through country condition evidence. If there are health issues, obviously you want medical records. I've heard this from judges specifically, that they generally don't like hundreds of pages of medical records. You'll want to ask your client to get a copy of their whole medical record, especially if they have serious health issues, but don't just submit the whole thing. A lot of it is just lab reports that don't mean anything to anyone, or, you know, there's just pages and pages of form that's repetitive. You'll piss the judge off if you just provide all of it. They would rather see a few detailed letters from doctors explaining the situation. Then you can pull out areas of the medical records that show, you know, a surgery, or show a detailed, what is it called? The history of the client's condition. You know, you still will want to provide detailed medical records, a big chunk of medical records if possible, but don't just submit the entire thing. You also want to provide school records, you know, whether it's a spouse who's in college or minor children who are in school, showing that they are in school, doing well in school, involved in extracurriculars, those sorts of things, especially if you have country condition evidence to show that they would not be able to go to a comparable school in the home country. That'll help show hardship. But if you don't have the proof the kids are in school and going to school, it doesn't matter how bad the schools are in home country. Especially if the child has IEPs or anything like that, disabilities, you'll want to show that, especially if that would not be available in the home country. A hardship evaluation, yes.
Let me just jump in and ask you a few questions. So how often do you use an expert in your cases?
Honestly, usually I don't, unless there is a specific factor in the case. For instance, if the client is diabetic, for example, and we want to show that in Guatemala, the client would not be able to get the same access to treatment in Guatemala, including, for instance, getting insulin, going to regular doctor's appointments, you might want to get an expert to specifically testify to something like that. If, or, you know, if, for instance, it's a gay couple, a homosexual couple, and they will face discrimination in the home country, you might want to get an expert for that. So a lot of things, it's, you know, it's fairly straightforward. Basic country conditions will show it, but if there's really one specific factor, you might want to get an expert to testify as to why that would be specifically difficult in the home country.
And then we have another question. Must the qualifying relative be a U.S. citizen?
No. So I thank you for asking that. The qualifying relative could be a U.S. citizen or an LPR. But unfortunately, like TPS, any other sort of immigration status does not qualify. It has to be USC or an LPR.
And then someone asked a general question about having a case with 4 qualifying relatives, a U.S. citizen spouse and 3 U.S. citizen children, but one of the children is 20 and will age out next spring. The individual hearing is scheduled for November. He's wondering if he should feel bad if we can't include all possible qualifying relatives. I don't think you should feel bad. As long as you can demonstrate hardship to the other qualifying relatives who are not aging out, then I think you should be good.
Yeah, and I think that's fine. I wouldn't stress out too much about it, especially since you should be able to still tie that hardship to that child, even though they won't be a child, to the other family members. Because, you know, if you're still looking at a family separation, that sort of thing, it would still be hard on mom if, for instance, adult child had to stay here in the United States while the rest of them went to home country, something like that. Yeah, you should be fine with a case like that. You can, their lives and hardship would still be relevant. It's just not directly relevant. I saw another question.
Yes, another question. I think the attendee just missed your answer to this. Is it best to file at the master hearing or prior to the application for cancellation of removal?
I file it as soon as possible because that's the key to getting your client the work permit. And honestly, judges never mind when the application is still on the file. It looks good for you. It looks like you're prepared. It looks, the client's happy, they get the work permit, the judge is happy, you're doing your work. But there really is nothing wrong usually with going to a master calendar hearing and pleading, saying I want to apply for cancellation of removal without the application. It's not an absolute requirement. It's just best practice to file it as soon as possible. If there any other questions, are we good?
I think we're good.
Oh. Hardship evaluations are the next thing. This is usually done by either like a social worker or a therapist, because what they would help do is establish the emotional and mental hardship that your client would suffer. Obviously, in an affidavit from a client or a qualifying relative, you will want to say, you know, I would miss my spouse, or it'd be really hard to relocate and leave all my friends and family behind. But a hardship evaluation will really help to bolster those arguments, because maybe there's already a history of slight anxiety. The qualifying relative might not have an actual diagnosis for anxiety, but when talking to a therapist about you know, the future, if the client has to be deported, they can say that there's, you know, increasing anxiety, or there's a danger of PTSD and more in danger because of family, you know, a history of whatever. So the hardship evaluation really is important, and I do suggest you get them done for every cancellation of removal case, because sometimes that alone can be enough to show the hardship. And then you also want to show ties to the community. So letters, we already kind of went over the letters of support, but what these letters will also do is establish that the family and the applicant have, you know, a support system here in the United States. Especially if they say that they would have to relocate to home country, showing that they are losing a large support system would be hardship. So if they have many family members in the community who live nearby, and the kids go and hang out with cousins and aunts regularly, but that would not be possible if they lived in home country, that's hardship. You'd also want to show evidence of involvement of extracurriculars, especially if you have children, if they're, you know, on the soccer team and on the debate club and in chess club, and those are things that they would not be able to do in the home country, that is hardship. Financial hardship will usually play into every case. Submit bills, and usually in the affidavit, I'll outline what the client's expenses are and what the income is. If you know, a lot of times these cases, the person in removal proceedings is dad, who is primary earner. Explain why mom would not be able to support children if dad were not here working in the United States. That's an example of where mom might not be a qualifying relative because she also does not have status, but it would be hardship on the children because mom would not be able to financially provide for the children without the help of father. And with that, like I said, bills, because you want to corroborate that these are the expenses that the family has. So these are the basic things, but again, get creative. Every case is a little different. You might have a hook that is different and unique to your case. And you just have to find a way to make it rise to that level of hardship in order for your case to be granted. Definitely talking to your client about their lives day to day will help you establish and figure out what evidence you need to show the hardship.
So Kate, how do you handle a case where, you know, at the time client came to you, there was exceptional, extremely unusual hardship, but maybe their merits or individual hearing is set maybe 3 or 4 years from now. And during that period of time, the hardship is kind of diminished a little bit. How do you handle that?
I've definitely dealt with cases like that. For instance, you know, a client has severe medical issues, but then, I'm sorry, the qualifying relative has medical issues, and then maybe the medical issues have cleared up, or the qualifying relative was in school and isn't necessarily in school anymore. For things like medical records, strike that. Don't be afraid to kind of talk about future in terms of what possibly could happen in the future, or what the client would be losing in the future. So for instance, maybe the qualifying relative had health issues, they've cleared up, but there's always the possibility there could be flare-ups. Get a letter from a doctor explaining why, access to medical care is important for a client, even if they, if cancer's in remission, but they still need screening, or the diabetes is under control, but whereas before they were in and out of the hospital, something like that. Get a letter from a doctor explaining why it could still be an issue in the future. Also things like future access to education, such as, if a qualifying relative wants to go to school to become a nurse, but they're not technically in school right now, you can still explain that and explain why those future opportunities would be cut off if the client is deported.
Awesome. So just a follow-up question, in the financial area, did you say that the family bills would be a consideration for financial hardship?
Yes. So you always will have to tie it into the qualifying relative, but family bills. I had a case, this is like a prime example of the applicant only had one qualifying relative, and it was a 7-year-old son who was healthy, had no issues. There was nothing remarkable about the actual son. Wife was undocumented, and client also had several other undocumented adult children who also had a bunch of grandchildren who were United States citizen children. So the grandchildren didn't qualify, the other children didn't qualify, the spouse didn't qualify. But the factor in that case was that this client had worked for a really long time for this farm, and the whole family lived on the farm and had housing on the farm. So I was able to show that even though those weren't qualifying relatives, if client was deported, all of these people would lose their housing. And that would adversely affect the qualifying relative, the young boy, because he was growing up with this great family system. And so they all would financially lose housing. They all would financially lose their support. And I showed how each individual person would not be able to necessarily provide for the family and would have to move and do all these things because of the financial benefit that they were gaining from my client, and how that would impact the son. So that's just, so always, if you can show finances, you can show, and how, because even if, for instance, I've even argued that, say a client is sending money to family in home country, that how that will impact the family, because if that family loses their stream of income, and you can kind of just branch it all out, how it's all going to impact the family, because then other people will need to help that family, et cetera, et cetera. You have to get creative and find a way to make it all tie in, but financial is almost always going to be a factor in these cases. So find a way to make it work.
So our last question is it possible to waive the filing fee if a client has been out of work for months due to COVID?
I believe so, but I don't remember, especially since I know fee waivers have changed. So
yeah, I know they've changed, but I don't know if the regulation has been put into place yet. I've never had to do that personally, but I know that you are able to request a waiver of the filing fee. I haven't tried it for, because they've been out of work due to COVID specifically, but I would just look into that requirement.
But yeah, I do believe you can waive it. You would request the fee waiver with the judge, file it with the application along with the proof of the person being out of work and the inability to show bills. It's similarly with the medical records. Obviously you want to submit bills to corroborate any financial argument, but also include either a chart to show the total of all the bills plus the income, and show how that equals a negative. For example, if they're only bringing in $500 a month, but rent is $1,000, car payment is $300, do the math to show how it's a deficit of $800, that sort of thing. Make it easy for the judge to kind of see it, and then the bills the judge doesn't actually have to pore over the bills. They'll just see, okay, what they're saying is true. They're not just making up these numbers.
Awesome. So that's all the time that we have for today. Thank you to Kate for sharing your knowledge and your expertise and your time with us. Thank you to the attendees for participating and for asking questions. Just to let you know, this webinar has been recorded and will be uploaded to the MSBA immigration section page, and along with the PowerPoint as well. So you can access it later there. Thank you so much. Have a great weekend, everyone. Take care.
Bye. Thank you.